Good morning or good afternoon, depending upon which time zone you're located in. I am Mike Lockerby, one of the co-chairs of Foley's National Distribution and Franchise Practice Group, and want to welcome all of you to today's webinar. I see from the list of attendees that we have a number of people who have previously been to our annual Law of Product Distribution and Franchise Seminar. We have some newcomers as well. We also have some people who were at our first Distribution and Franchise Coronavirus webinar back in April. The focus at the time was on surviving the shutdown. And of course, most of us are through that phase and are trying to get back to business as normal as much as possible. For those of you who missed that webinar or would like other resources, we have available on the Coronavirus Resource Center a tremendous array of publications, prior presentations, etc., that I think you will find of interest. Today's focus, however, is what happens next after the pandemic. And we have a panel of experts on various topics. First, you'll be hearing about the supply chain from Vanessa Miller, a partner in our Detroit office. Then Leslie Smith will talk about force majeure clauses, and that's an issue that cuts across a lot of these topics, including not only the supply chain, but some others that are coming up. Leslie's based in our Miami office. After that, you'll hear from Max Chester and Andy Meerkins in Milwaukee about COVID-19 related insurance issues. Following that, Toni Prestigiacomo in our Madison office will address a number of real estate and finance issues that will be of interest to both manufacturers, franchisors, and their dealers and franchisees. And finally, last but not least, on the subject of bankruptcy, Tom Scannell in our Dallas office will be presenting, and his straight man will be Peter Lowe, Vice Chair of our Distribution and Franchise Practice Group, also based in Dallas. So with that, I'll turn the floor over to Vanessa Miller.
Thank you, Mike. Greetings, everyone. When this first started, when the pandemic first started impacting supply chains, it was abundantly clear just how global supply chains have become and how there was impacts as early as January 2020, given the critical components that are sourced from China and throughout Asia. Then we saw in March the pandemic spreading to North America, and then the unprecedented flurry of executive orders taking place here. And companies were forced to really take a swift and reactive approach to managing their supply chain. COVID-19 became the stress test, the perfect storm of a sort, to look at weaknesses embedded in companies' existing supply chain, and then to really highlight areas for improvement going forward. And I think that's where companies are turning their attention now, that business is starting to resume, and realizing that they need to invest additional time to strengthen their supply chain. Many industries operate under what is called a just-in-time production model. That the purpose of just-in-time, it has a number of positives to it. It's really a workflow methodology that is aimed at reducing flow times, minimizing the product you have on hand and the inventory you have on hand, so that you only order and produce and receive product if there's demand for it. There's a lot of efficiencies associated with just-in-time. But when just-in-time breaks down as a result of some hiccup with respect to availability, some pricing or raw material shortage, it can cause a ripple effect across the entire supply chain. And we certainly saw that with the pandemic and the significant impact it had on just-in-time inventory model. Companies had to swiftly establish what I call an interdisciplinary crisis response team across all areas in order to address the pandemic. But now they're turning to look at what are next steps to a proactive, longer-term solution to future supply chain to avoid to avoid future supply chain disruptions and look at how to increase flexibility and resiliency going forward. One thing that we saw throughout the pandemic was companies engaging in a supply chain mapping process. Manufacturers, many still have to rely on a single source for their supply of materials because it's specially qualified good, especially manufactured good. And they order all of their requirements from a single supplier. This drives a lower cost, of course, because you can offer really high volumes to one supplier and drive them to get their best price. But post-COVID-19, we're seeing companies begin to consider, would it be better to have a more flexible, more reliable supply-based model? And the very first step in this is to look and figure out where all your products are coming from. Not just where your products are coming from, but of course where your sub-suppliers and where their suppliers are coming from, all the way down to the raw material input, in order to really understand the entire flow of the process. And then also looking at what sorts of risks can occur depending upon the location and the source. What has occurred in the past? What do we foresee looking into the future, additional risks and possible interruptions to the continuity of supply? Once all of the highest risk areas and links have been identified, companies can prioritize accordingly to figure out which areas they need to shore up. For example, should they identify and qualify dual or multiple sources for the products? And then is there an opportunity to implement a warehousing requirement or some kind of a safety stock requirement, even if you don't have the capacity to keep those products, the bank of parts on hand? Can you require your suppliers to keep some additional amount, some safety stock amount available for you at some alternate location? And then a number of companies rely very heavily on third-party logistics providers. And we saw this during the pandemic, and still, as companies are ramping back up, it's been a major problem because especially those companies that are very operationally dependent on their 3PL provider, they've had a hard time keeping their workforce in place during this. And they've lost a lot of institutional knowledge, and there's been a lot of problems getting ramped back up. So making sure not just your company and your supply base is ready, but also that your 3PL providers have a plan in place. So what is another lesson learned? Well, certainly we've seen that cost should not be the only consideration. Sometimes companies learn this lesson a hard way because they'll have a major quality issue that occurs because they selected a low-cost supplier whose cost was far lower than other suppliers, the other bidding suppliers, but it didn't raise a red flag with procurement, and instead some quality issue or some delivery issue occurs. But we're now seeing companies looking at more ways to ensure that they have a diverse, resilient, and really flexible supply base. Cost is always going to be the main factor, but a number of other risks should be taken into account. For example, if a company does decide to dual source a component to minimize the risk of an interruption to supply, then it should look at possibilities of dual sourcing that component from 2 different locations, because this really shores up the risk of a force majeure event or some other impact coming out of the same region that would impact both suppliers at the same time. Some other ways to ensure greater flexibility include expediting the approval process for alternate suppliers, where there's approvals required from your customers, or looking to see if some of the functions that your supply base is performing can be done in-house, even if only temporarily, which we did see occurring in the last 3 months. Now, Leslie is going to talk much more about force majeure, but as she will tell you, we have known the importance of the force majeure clause, and we thought force majeure was important much before the pandemic, because once a year or more, some major disruption occurs in manufacturer supply chains as a result of a force majeure event. So Leslie's going to talk more about the force majeure, why it's a creature of contract, and some considerations for your contracting. The last few years have seen a lot of discussion about force majeure, mainly surrounding the tariffs that have been in place. Likely these are not a force majeure event because they don't prevent performance, which Leslie will describe. They just make it more expensive. And force majeure is not a mechanism to obtain a price increase. But already there was a kind of a shift away from China as a result of the tariffs, and companies were looking at options for reshoring their product closer or to different locations away from China where there's been a lot of focus of the tariffs and trade wars. In addition to the force majeure claims that Leslie will focus on, there were a number of other costs that were incurred as a result of the pandemic that companies are going to be sorting out, probably not in litigation, more likely through negotiations from customer to supplier. We saw a number of things occur, such as warehousing costs. Suppliers had already built parts, but they were not able to be delivered because the customer had sent force majeure notice that it was shutting down due to the executive orders. There were situations where suppliers had parts on the water, already in shipment, in transit, and those parts needed to be returned. Which party bears the cost? And then a lot associated around the ramp up, freight expedite, going from a cold start back up to high volume, had a lot of additional costs surrounding it, overtime and ramp up costs. So unfortunately, many of the supply chain contracts did not deal with those, but going forward, companies can allocate risk in their contracts, and they should give additional thought to these, what were previously unforeseeable costs, but can be allocated by contract. What is one final area where we really have seen a trend, and that is companies examining and looking for quicker ways to adopt and implement new technologies. There is the end-to-end connectivity in the supply chain, sorts of anticipatory logistics software like EDI that allows shippers and manufacturers to estimate orders before the orders are actually placed as firm orders. We've also seen an uptick in companies relying heavily on digital freight tracking platforms that show real-time raw materials, their supply base, and where products are, so they can react very quickly if there's any issues or delays. There already was an uptick, an increase in AI and robotics, including the use of cobotics, where robots operate side by side among humans. But we expect this to go forward even more quickly for a couple of reasons. First, robots don't get sick. Second, companies are looking for creative ways, as I mentioned, to bring manufacturing closer to their end location, but making it feasible from a cost perspective. So there's going to be more emphasis on technology and innovation in supply chains than ever before. Now with that, I will turn it over to Leslie Smith to talk about force majeure.
Great.
Thank you, Vanessa. And before Leslie begins her presentation, I wanted to mention to the audience that there is a Q&A feature, so that if you have questions, please submit them, and we'll try to answer as many of them as we can. So, Leslie, with that, proceed.
Great. Thank you, everyone. Appreciate it, Vanessa. With regards to force majeure clauses, some of you maybe deal with these, as Vanessa said, on an annualized basis. But for some of us, you haven't perhaps even heard about the term since your first year of law school if you're an attorney. So taking your 1L contracts class. So we'll just do a brief overview on force majeure to refresh our recollections about it, and then we'll talk about it in a couple of different industries and applications that we've seen since the pandemic. So generally, with regards to force majeure clauses, those are clauses that typically end up in the miscellaneous section of a contract, and they excuse performance by one party or the other, or in some cases both parties, when there's a defined contingency that is beyond the party's control. They are, as Vanessa mentioned, they're a creature of contract. This is not a function of common law. And the terms of these clauses are very contract specific. They can be written in favor of one party or another, or mutually a product of negotiation. But the terms are important because the courts tend to strictly construe them. So what do they cover? Well, the traditional clauses that you probably have seen in your current contracts, or those you've engaged in previously, talk about weather conditions, casualties such as fire, condemnation, war, strikes, the ubiquitous acts of God, and then sometimes government regulation. But less common terms, but obviously more apropos of what we're talking about here today, are those that mention specific things that would be tied to what we're experiencing now, which would be a disease, an epidemic or pandemic, public health emergency, curfews, and quarantines. Those are much less common clauses, but I suggest to you they're probably going to become much more common as parties look and evaluate their contracts. When a court is faced with a force majeure clause and one party invokes it, the court is typically going to look at three factors. And they're going to consider, is the obligation that's been interrupted covered by this clause? They're going to also ask themselves if the event that's causing this interruption falls within the parameters of the clause, and did the event that causes the interruption actually prevent the party's performance? Because parties will often attempt to invoke a force majeure clause and claim, well, it's costing me more to get the product. Not that I can't get the product, I can't buy it at the same price that I did before. That in and of itself, unless it's addressed in your force majeure clause, is not going to do it. The performance must be prevented. It can't just be more costly. Now, if you're without a remedy because your particular contract doesn't contain a force majeure clause, you may be able to avail yourself of these well-known common law and, in one case, UCC remedies. Again, going back to 1L in contracts, frustration of purpose may provide you with another avenue for argument. Impossibility or impracticability of performance is another common law doctrine that's popping up a lot these days. And as well, within the UCC context for the sale of goods, that's actually codified at Section 2615 as commercial impracticability. So you may not be wholly without a remedy if you need to avail yourself of a claim that the pandemic has impacted your ability to perform an obligation in a contract, or you're resisting one from. So I want to talk to you a little bit about some of the places where we've seen these arguments on force majeure come up most frequently. Obviously, lease agreements. As you know, around the middle of March, many businesses, by court order, the shelter-in-place orders that were put in place by the various governors, mayors of cities, et cetera, that went into effect, had a tremendous impact on a lot of landlords and tenants. There were performances that landlords and tenants could not realistically perform given certain shelter-in-place orders. It might have been a promise from a landlord to deliver a built-out space to a tenant within a time certain and wasn't able to complete that project. The landlord wasn't able to provide the tenant with a quiet enjoyment. And that, I thought, could be construed a lot of ways. Typically, quiet enjoyment is your peaceful possession of your premises. But if you're not in possession at all, are you really then, you're not able to enjoy the quiet enjoyment of your property? Obviously, one of the big ones that's been argued is the ability to pay your rent. I did find one case, interestingly enough. Last month, the bankruptcy court in the Northern District of Illinois actually cut a tenant's rental obligation. This was a commercial restaurant enterprise by 75%. The court relied, in fact, on the force majeure clause and cited to Governor Pritzker's March 16th order, which was closing restaurants for in-person dining. Now, the court got to the 75% by virtue of the fact that the commercial kitchen in the restaurant was still operable so that the restaurant could have takeout and delivery orders. So that's how the court sort of worked its magic with regard to that clause. And I've got a couple more cases I'll talk to you about, and if you want citations for them, send me an email afterwards and I'll be happy to provide them. An obligation that a tenant may have is one of continuous obligation to, in fact, be in business and this is very common in commercial retail establishments where a shopping mall operator wants the store to be operative a certain number of days a week, 6 or 7 days a week, between certain hours. That's also been interrupted in some cases with the pandemic. Now, in most cases where there is a force majeure clauses, there is typically another less happy clause for a tenant, and that is an obligation to continue paying rent no matter what, essentially. And that type of language often appears in a lease provision as the tenant's requirement to pay rent without abatement, set-off, or deduction. I haven't seen a case yet that's, interpreted the friction between that and the pandemic based on a force majeure clause, but that may well be coming. Now, let's talk about it a little bit more in context of the supply chain. Vanessa covered that pretty thoroughly before, but I will tell you within this arena, we haven't obviously fully recovered. There are still going to be hiccups within the supply chain. And so this is a time, if you've been impacted already and you've gotten the supply chain going again, it's a time to take a further assessment and see what needs to happen next. So, as we said, we recommend that you go back and look at your clauses up and down the supply chain. If you can get others in your supply chain to provide their contracts to see what they're like, that's even a better way to further protect yourself. But when these force majeure clauses come into play with suppliers, what often happens is that the clause themselves will say that the force majeure, you are excused from some obligation for either a specific period of time or until the event is over. So you need to evaluate whether, even though this pandemic may still be in effect, whether in fact your force majeure clause only protects you for a limited period of time. You also need to know if there's an inability during the course of the force majeure clause that prevents performance for some long-term period of time, do you have the ability to terminate the contract, and do you want to do so? Also, some force majeure clauses have a condition precedent, which is a written notice. You can't avail yourself of them unless you have in fact told the other party that you're invoking the clause to your benefit. I didn't find any cases that have been cited with regards to force majeure clauses in the supply chain arena since the pandemic. I did find one that predated that, which was a fight between a manufacturer called Techstar, who made certain parts for Solyndra, which you may remember was a solar panel manufacturer, a company out of California that got involved with some questionable issues and ultimately collapsed with a lot of government infusion of capital despite that. But these were two sub-suppliers there, and Techstar and Tenement were in the contractual relationship, and Techstar had contracted with Tenement to make certain products for it. Techstar ceased paying. Tenement sued, looking to be paid, of course. And one of the things that Techstar tried to argue was that, in fact, there was a force majeure event, and the force majeure event was Solyndra's financial collapse, which he deemed to be an unforeseeable event, which should excuse its performance and obligation to pay Tenement. The court didn't like that argument too much. It said that, in fact, it was a cash flow issue for Techstar, and that, indeed, they needed to still pay their obligations. But I thought what was also interesting about this case was the court noted that what Techstar could have done was put in its contract with Tenement a requirement that it wasn't obligated to pay Tenement unless it, in fact, had been paid by Solyndra. The clause said such a provision might have protected it. It didn't include that as a term in its contract with Tenement, and therefore it was not off the hook on its payment obligations. Excuse me. So what we just say to you here with regards to these issues as you're seeing them in the supply chain is just be a realist. You know, this is a time to assess your business relationships, the ones you want to continue and those perhaps you do not. Is there an opportunity here to negotiate some price adjustments, some timing and delivery adjustments to account for what's going on? And again, as Vanessa had mentioned earlier, is this a time that you need to consider diversifying your procurement sources? And maybe that's across different suppliers, across different parts of the country. And as she mentioned, even if it's more expensive, you might be able to ensure continuity and delivery of your supply. Again, be sure to plan ahead and figure out what you need to put in your contracts on a go-forward basis to further protect yourself from any adverse consequences that you've been experiencing over the past few months. It may be that you want to have agreements with your supply sources on when the pandemic subsides, what the obligation will be to procure, to provide the supplies, and whether that's going to be immediate. I mean, do you have to ramp up production immediately, or can you get lead time on your production? These are all the questions you need to be asking yourself as you look forward to living with what I think is what we're all calling the new normal. One last industry that we'll talk about is franchise and dealers. There has been a lot of discussion, obviously, among franchisees with their franchisors or their dealers, with manufacturers. In the franchise arena, it's very common to see minimum royalty payments. So typically there is a little bit of a protection for a franchisee. Under normal franchise agreements, a requirement is to pay a percentage of your gross revenues. But in some instances, there's a requirement to pay a minimum royalty. If that's the case, franchisees are working hard to renegotiate those with their landlords and get deferrals of those or add them on to the end of the term. Franchisees have tried to use the pandemic to avoid opening deadlines. And again, the force majeure clause may protect them in that instance. I mean, if they're required by a franchise agreement to be open by a date certain, and there's a shelter-in-place order in effect for in-room dining, franchisee may have a very good, legitimate argument as to why it can't open by the opening deadline. Same with an area developer who is required and obligated to open a certain number of franchised units by a date certain. They again may say, it's not financially feasible right now, the demand is down in this particular community. So again, using the force majeure clause to negotiate a better and more relaxed opening deadline. Operating restrictions. We dealt with a franchising client who had initially not permitted any delivery services from its restaurants, such as Grubhub and Uber Eats. But as a result of the pandemic, the only way the restaurants could have survived was to allow delivery features. So that was a negotiation between the between the franchisor and franchisee to relax those operating restrictions. Same with exclusivity and territorial limits. You're seeing a lot of tension coming up because deliveries are being made outside of territories that typically were allowed to service and were more confined. So this is the force majeure clause and its impact on franchising and dealer agreements is becoming quite prolific, and I don't think we've seen the end of this yet. I'll also discuss just very briefly with you, what you need to do is, if you're the franchisor, is figure out, what it is. Does your force majeure clause, in fact, really speak to the situation? Franchisees who are being pinched for cash are looking for ways to extend or avoid payments, and they will try to invoke the clause, perhaps properly in some instances, but in others, perhaps not. There's a case, this was not a post-pandemic case, but a Wyndham Hotel case out of the Southern District of New York, where the franchisee was terminated by the franchisor, Wyndham Hotels, after the government had in fact seized the hotel for failing to pay. It was a hotel and casino in Panama, had failed to pay this gaming taxes. The franchisee argued, I couldn't pay, I wasn't able to in fact operate, and that's why I wasn't able to pay royalties, and you improperly terminated me, and by force majeure, I should be entitled to be relieved of the obligation to pay post-termination damages. Well, the court said, of course, not surprisingly, the failure to pay your gaming taxes was wholly within your control, so it didn't fall into the unanticipated event that are typically covered by force majeure clauses. So the franchisee was not off the hook in that case. But interestingly enough, that was a force majeure clause that had a pandemic term in it, one of the few that I've seen. Just very briefly, because I know we're running low on time, within the franchisor world, very common for franchisors to enter into supplier agreements to help its franchisees get preferred pricing or a better quality of product to put in its hotel or restaurant, et cetera. And suppliers are invoking these clauses to not deliver the requested towels, the monogram towels, whatever it may be. And then the franchisor needs to determine what its options are and how to react. Agreeing that it's a pandemic and it's oh so sad may be one thing, but it might be that the language doesn't actually cover the situation, so you can resist it. Or if it's a supplier you want to continue to work with and have a good long-term relationship with, negotiate. See what you can do to reroute your orders, to get the first the first supply of orders that are shipped once shipping is reinstated, or perhaps looking to your insurance, which Max and Andy will talk about more briefly here with you in a moment. And finally, if you are the franchisor, perhaps you invoke the clause yourself. You might want to, you don't have a need for 100 towels delivered to various franchisees in your system on a weekly basis. Maybe you want to cut those amounts of orders or concessions. This is the time for you as a franchisor to explore some better negotiating tactics and better outcomes and terms for yourself and your franchisees. So, having said that, I think we haven't seen the last of what this pandemic's going to wreak on us with regards to force majeure, but it'll be interesting to see how the law in this area develops. And now I'll turn it over to Max Chester and Andy Meerkins to talk to you about insurance issues.
Thank you, Leslie. And before Max and Andy begin, I wanted to mention that we have received a question about force majeure, and we'll save that for the end. And of course, we're not giving any specific legal advice in a public setting like this, and plus to advise someone about a force majeure clause, we'd have to see the clause itself. But Leslie, you'll see the question while Max and Andy and the others are presenting, and basically it has to do with the issue generally of whether a monthly payment that contemplates that a venue will be open is still required when the venue is not open. And that's probably all I should say without disclosing too much. So with that, I'll turn it over to Max and Andy to address the COVID-19 related insurance issues.
Thanks, Mike. This is Max Chester from the Milwaukee office with my colleague Andy Meerkins. We'll address 4 issues relating to COVID-19 insurance topics. The biggest one of them is, I guess, business interruption insurance. I'll talk about that briefly. Then Andy will talk about losses occasioned by orders of civil authority to close and potential coverage for that. Andy will also talk about issues for COVID-19 relating to CGL insurance and claims. And I will finish with a discussion of the PrEP Act, which is an important federal statute that may provide immunity to many companies out there and is not to be overlooked. With respect to business interruption insurance, when the pandemic started in early March or thereabouts, everyone predicted there will be an avalanche of litigation relating to business interruption insurance claims, and there have been no disappointment in that regard. Many policies contain coverage reimbursing lost business income caused by, and this is a key phrase or variation of it, direct physical damage or loss to property. And again, a lot of insurance forms are standard, so maybe the phrase is not verbatim in every policy, but a lot of them have this key component of physical damage or loss. So the question becomes for COVID-19 whether presence of potential virus or constitutes this requisite physical damage or loss. And obviously, specifics of the policy will dictate, but there are some important cases already decided, and that will lead the discussion of this issue. The insurance industry has taken a position that a virus pandemic was never intended to be insured. This is something that's only the federal government perhaps has the capacity to insure, and no premiums were ever collected for business interruption insurance relating to pandemic, and therefore COVID-19 losses are simply not covered. One statistic I think that's important and will be used by insurers throughout is the imbalance between the potential losses and the surplus of all of the property and casualty insurance companies in the U.S. Trade industry suggests that the surplus is somewhere around $800 billion, all combined for all of the property and casualty insurers to cover, anything above, reserved losses caused by hurricanes, fires, tornadoes, automobile losses, et cetera, et cetera, et cetera. That's $800 billion. While average monthly business income loss for all of the businesses in the United States, businesses employing fewer than 250 employees on a monthly basis is anywhere between $50 and $100 billion. So you can see how, if you just cover 7 months of losses, you will wipe entirely the surplus of the property and casualty industry, which cannot be, was never intended this way. I mean, some players out there did buy pandemic insurance. Apparently, the All England Club, which is the Wimbledon tournament host, has been purchasing pandemic insurance since 2002, following the SARS outbreak. And several insurers have stated that they will pay the claim, and it will be in somewhere between $150 and $200 million. But that coverage for Wimbledon was very specific and manuscripted. And then, generally since 2006, the Insurance Services Office, which a lot of companies use for their forms, has published what's called a virus exclusion form, which has been available to the market. And that form, if incorporated in the policy, basically excludes coverage, for any losses caused by viruses or bacteria or anything of that nature. A lot of companies, insureds, will be arguing that, absence of that clause when it's available somehow signifies that coverage is available. But I will leave it to courts to make interpretation of that argument. Hundreds of cases have been filed in the last 90 days seeking coverage for business interruption claims relating to COVID-19. In several cases, motions to dismiss have been filed, and there's briefing underway, no decisions yet. There are several efforts to consolidate all of those cases in the MDL, in either the Eastern District of Pennsylvania or the Northern District of Illinois. And the MDL panel has established a briefing schedule, and that briefing is underway, right now. A couple of interesting decisions in this area. The Pennsylvania Supreme Court, about a month and a half ago, declined to exercise what they call in Pennsylvania their, King's Bench jurisdiction or extraordinary jurisdiction to hear a case, and basically said this matter has to proceed in the ordinary fashion. About a month ago, in one of the cases filed in the Southern District of New York, a plaintiff sought a preliminary injunction, and during the hearing, the court denied a preliminary injunction, or TRO, I think rather it was at that phase. And during 20 minutes of oral argument, where the transcript is available, the judge was very skeptical about plaintiff's ability to prevail on the merits, saying that there was no physical damage to the property and property was accessible. In another case in Pennsylvania, a federal judge remanded the case to the state court, saying novel issues of state law have to be decided in this area. There is really no prior case law specifically deciding business interruption coverage for virus pandemic. But there are lots of cases that litigants will be claiming are analogous to the situations, and courts are all over the map on this. Courts have found coverage, for example, in cases involving smoke in an open theater that interrupted operations of the theater, gasoline and vapors contamination in the church that interrupted the operation of that building, friable asbestos, ammonia gas. All of those items left property completely inaccessible. At the same time, courts found no coverage in cases involving foul odors and bacterial contamination in ductwork, asbestos fibers as well, construction dust, yarn exposed but not affected by a covered peril, loss of electronic data, and loss of contract because the ingredient beef, for example, was stuck in Canada due to the mad cow disease. So, depending on the state, depending on the policy language, there are some cases that go back and forth, and the litigants will have to make the best arguments. Andy?
Thanks, Max. So the civil authority coverage is a close cousin to the business interruption coverage that Max was just discussing. The biggest difference between the civil authority coverage and the business interruption coverage is that under the civil authority provisions, damage does not need to have happened to the insured premises itself. Rather, this is sort of a typical clause here. This coverage is intended to compensate the insured for lost business income when a civil authority orders them to close or prohibits access to their premises. Now, notably, under this coverage, just like under the business interruption coverage, there has to be direct physical loss of or damage to property, just not the actual insured property. So that the issue that Max was just highlighting, that courts have been all over the map on what constitutes direct physical loss, is going to be directly at issue in any case involving the civil authority coverage as well. And courts have went both ways on that. There's an additional issue that is likely to come into play in cases that involve the civil authority coverage, which is sort of directly implicated by the various stay-at-home orders that cause so many businesses to close. And that is the two little words that you can see in the middle of that first bullet point, due to. Courts have been pretty uniform in that they want to see that the order of the civil authority is tied to some actual direct physical loss. The best way to illustrate this is by looking at a couple historical examples. And the context in which this issue has probably come up the most often is evacuation orders having to do with hurricanes. And there's actually a couple different cases that illustrate sort of this due to requirement pretty well. There was a case a few years back out of the Fifth Circuit Court of Appeals in Louisiana that involved Hurricane Gustav threatening the city of New Orleans. And the city ordered evacuation of local businesses, or evacuation order forcing local businesses to close. And a bunch of restaurants filed under the civil authority coverage. The court concluded that the coverage was not available because there was no evidence that the city of New Orleans order was due to any actual physical damage, as opposed to the fear of physical damage. The insureds had tried to point to some property damage and destruction that had sort of hit the Caribbean before it had reached Louisiana, but the court found that because that damage didn't appear to have caused the evacuation order, that the coverage was not available. So by the same token, in another hurricane case that was decided by a Georgia Court of Appeals, there was evidence that an evacuation order, that when the officials were considering an evacuation order, that they actually looked at the property damage that was hitting the Bahamas and used that as part of the basis for ordering the evacuation. And so in that case, the court actually found that coverage was available. And so you can see that it's sort of very fact specific. And in the cases of COVID-19, it'll remain to be seen how all this plays out. A huge issue that, like Max said, we'll have to see how it plays out is how courts treat the issue of whether direct physical loss exists at all. And then a second issue will be whether the order of civil authorities, closing businesses, was due to any physical loss or whether it was due to some other concern, public health or something. So those are probably the key issues that will define whether the civil authority coverage responds to COVID-19 claims. And it sort of remains to be seen. I mean, we've seen other similar issues arise kind of following the terrorist attacks of September 11th when the FAA closed, grounded all the planes. There was a lot of claims by airports and airlines and hotels for lost income, and courts grappled with, what was the cause of the FAA's order? Was it the actual previous attacks, or was it the fear of future attacks? And so we might, see similar issues come up in the COVID-19 context. So pivoting away from first-party claims, we have already started to see and should expect to see more of third-party claims, wherein as businesses start to reopen, people who inevitably will get injured and contract COVID-19 may allege that a business was negligent in safeguarding patrons or employees, what have you, from being infected by COVID-19. And in that case, businesses would look to their CGL or commercial general liability policies to defend them and provide coverage. And there's many issues that will likely arise pertaining to CGL coverage. So this is by no means intended to be an exhaustive list. But one of the issues that will almost certainly predominate is the issue of whether there's coverage at all, or whether these are excluded pollution claims, or that the presence of virus is pollution that is barred by a pollution exclusion in various CGL policies. Now, it's interesting because, kind of like Max said, there's a lot of somewhat standard forms, but pollutants and pollution hazards, pollution conditions are defined in various ways in different policies. And as a result, kind of like with business interruption, we haven't seen any cases specifically dealing with pandemics or anything like that. But we can draw some analogies from cases that have dealt with viruses or with mold and things like that. And they've been, in certain cases, they've been found to bar coverage because it was excluded as pollution. And in other cases, courts concluded that this wasn't the sort of pollution that was intended to be excluded. So it's kind of a, who knows how these things will come out issue. Another issue relates to determining the number of occurrences under a CGL policy. So CGL policies, as you may know, are usually occurrence-based, meaning that each occurrence or accident is subject to a separate limit from the aggregate limit in many policies. So this can have a significant monetary impact because if there's a single occurrence, it may be subject to a lower limit than if you have multiple occurrences, which could enable the insured to access additional insurance funds. This is, again, going to be very fact-specific. And different states take different approaches to determining the number of occurrences under a CGL policy. Many states use what we call a cause approach, which looks to the underlying cause or causes of the injury. A minority of states actually look to see how many people were harmed and focuses less on the actual cause of the injury. So as an initial matter, in states that use a cause approach, it would seem more likely that the cause approach would lead to the conclusion that there's only a single occurrence caused by the virus. But courts have come to a number of different conclusions, even under that same framework. They found single occurrences. One court found a single occurrence in the case of a restaurant that served people food contaminated with E. coli. They found that sort of the occurrence was the single act of serving contaminated food. By the same token, another court in Illinois concluded that each serving that the restaurant served that contained food containing botulism constituted a separate occurrence or accident, enabling the insured to access multiple policy limits. So again, it will be sort of a fact-specific, jurisdiction-dependent analysis, but this is just one of the many issues that is likely to affect coverage under CGL policies.
All right. Thanks, Andy. And very briefly, because we're running out of time, I just want to touch on the PrEP Act. It may not apply to many participants on this call and the companies you work for, but it's not to be overlooked. It may, based on the definition of a covered person. So the PrEP Act basically authorizes the Secretary of Health and Human Services to declare a national emergency, which limits legal liability for losses to quote-unquote covered persons who are involved in the deployment of covered countermeasures, which are defined terms in the statute and the declaration of the Secretary. And such declaration was made in February of 2020, and it basically provides a limit to liability on to covered persons engaged in covered countermeasures through October of 2024. I'm not going to go through the definition of covered person and covered countermeasures, but it's basically anyone, distributor, program planner, qualified person, manufacturer involved in producing covered countermeasure, which is also broadly defined, and specifically for COVID-19 relates to masks and other equipment that some people may be making. And so if there is a claim in connection with any use of that material or preparation of that material or distribution of that material, the PrEP Act immunity may apply. In the advisory opinion, the General Counsel's Office of the Department of Health and Human Services declared that even if the person is ultimately found not to be a covered person, or even if the countermeasure is ultimately found to be not a covered countermeasure, as long as the person had a good faith belief, that may provide immunity from liability. And obviously, it's important that the activities have to relate to something that the federal government or other governmental authorities dealing with COVID-19 have, asked, manufacturers or other companies to provide. The only exception to liability immunity under the PrEP Act is willful misconduct, which is defined as basically intentional wrongfulness. And in order to sue someone under the PrEP Act, the person first has to file a lawsuit. It has to file a claim with the compensation program, and if the compensation program, which is a separate established fund, accepts the claims and makes the payment, then there's no lawsuit. But if the person wants to proceed under the willful misconduct exception, that lawsuit has to be filed in the District of Court for the District of Columbia, and it is subject to heightened pleadings requirements, and there is no recovery for non-economic damages such as pain and suffering. So don't overlook the PrEP Act immunity if you're facing any claims for any activities that might relate to COVID-19 measures. That's all we have. Thank you. Mike? Toni?
Yes. Hello, everyone. I'm Toni Prestigiacomo. I am a partner in the Madison office of Foley and Lardner, and I will speak to you today on real estate and finance issues post-pandemic, specifically rent relief considerations for commercial landlords and tenants and also post-pandemic commercial loan issues and opportunities. The economic damage caused by COVID-19 is turning out to be much more severe and proving to linger a lot longer than initially expected. I think all of us would agree it's not business as usual quite yet. Many tenants have gone out of business, are only partially operating, or remain closed due to continuing government shutdowns or restrictions. As a tenant, even if you received a rent deferral or abatement from your landlord during the past 3 months, most landlords recognize you may still be dealing with a lack of sufficient cash flow and inability to access additional working capital. We've seen that landlords want their tenants to stay in business, especially since COVID-19 has reduced their pool of potential new tenants. However, landlords are also struggling with how best to deal with a distressed tenant's request for rent relief or default, given their own responsibilities to pay maintenance costs, real estate taxes, and debt service on their real property. Nevertheless, we believe many landlords are more likely to forego profits during the short term in order to keep their tenants afloat. As a result, now may be a good time to request a lease amendment or even consider renegotiating your lease. Renegotiating or amending a lease is going to require that both landlord and tenant assess a variety of circumstances, many of which remain in a state of flux and are continuing to evolve due to the uncertainty regarding the timing and extent of the lifting of the stay-at-home orders throughout the country, and also the concern of a second wave of the virus coming later this year. So as you consider lease amendments, both from a landlord and tenant perspective, even though it may be tempting to renegotiate your entire lease, there's a good deal of support for maybe only negotiating short-term amendments, just given the uncertainty and not knowing where your business will be 3 months from now or 6 months from now. And that may be the landlord may be having the same issues. So just keep in mind short-term amendments may be more beneficial given the circumstances. Before entering into any negotiations, there are some key issues that both landlords and tenants will want to consider. For example, from a tenant perspective, as you consider rent relief, it may come in the form of a rent deferral, a rent reduction, or a rent abatement. You'll also want to consider if the deferred, reduced, or abated rent will be only your base rent or if it will include your pro rata share of your pass-through obligations for operating expenses such as insurance and real estate taxes. Also, for tenants, as you're contemplating your rent relief, please don't wait until you're in default. It makes sense to approach your landlord now. Be proactive. If in fact you get to a point where a landlord agrees to defer your rent, expect that rent deferral to be treated almost as if it's a loan, and you and your landlord will need to agree on a repayment schedule for the deferred rent. Landlords will want to include acceleration triggers for early repayment of the deferred rent should there be an additional default by the tenant under the lease, or should there be the occurrence of another adverse event, such as the tenant closing down permanently. Another thing to consider are security deposits, additional collateral. We've had many tenant clients successfully request landlords apply their security deposits to their unpaid rent obligations, but we've also had many landlords reject this request. Don't be surprised if as a condition of a rent deferral, a landlord might in fact require additional personal guarantees or additional collateral to secure a tenant's obligation to pay rent. As a tenant, you might also want to review your lease and consider what your operating covenants say. Consider if you have kick-out and recapture clauses. Consider your renewal options. Maybe in exchange for a rent deferral, you agree to renew your lease now or extend your lease. Consider material adverse effect and other default provisions under your lease. Also, in exchange for a landlord amending or modifying a lease, don't be surprised if a landlord requires additional reporting from tenants with regard to financial condition and operating status. Landlords, you need to separately analyze each tenant. A landlord needs to understand the financial viability of its tenant. You should be asking for financial information to verify each tenant's claim of hardship. Understand whether the tenant's business is likely to recover and how the business will recover, and the timing surrounding that recovery will be integral to deciding how best to amend the lease. Landlords should also consider, and as I say this, I pause just based on Max's presentation, but we've told landlords to consider if tenants have other means of getting assistance, whether that may be through business interruption insurance, whether they've applied for any of the federally backed loan programs under the CARES Act. Many landlords have said, tenant, go out and first exhaust your other options before you come to us and ask for rent relief. So understanding the tenant's situation is very important in terms of how the landlord decides to defer or if to defer rent. Another thing a landlord should consider is whether or not the tenant is in compliance with its other lease obligations. Before granting relief, the landlord's going to want to know that the tenant isn't in default of any other provisions, such as, for example, maintenance provisions, or if the tenant has insurance obligations, the landlord will want to make sure the tenant is current on those obligations. Tenants should be prepared to provide landlords with all of this information, including information on any government assistance it's received. Before entering into lease modifications, landlords and tenants both should consider whether any third-party consents are necessary. Many loan documents require lender consent to lease modifications, so you'll want to make sure that as you modify your lease, you're not violating your loan documents. Finally, before entering into discussions with tenants, landlords should consider entering into pre-negotiation agreements. These pre-negotiation agreements will confirm that any and all discussions and negotiations relating to rent relief will remain confidential, that they won't be disclosed to third parties. You'll also, from a landlord perspective, want to make certain that all discussions and negotiations are non-binding and won't be deemed to waive any of the landlord's rights under the lease unless and until a written agreement is entered into. Finally, with regard to lease negotiations, whatever deal you negotiate, whether as a landlord or a tenant, make sure that what you agree to is realistic given your circumstances and that you're able to hold up your end of the bargain, whatever that may be. And finally, always get your agreement in writing. It goes without saying you want a written amendment. Moving on to commercial loan issues, and I'll say opportunities. Unfortunately, we'll continue on a theme of a post-pandemic recessionary environment. Even after businesses resume their operations, borrowers will likely continue to experience liquidity and supply chain disruption. These have a potential to trigger material adverse effect, insolvency, and going concern risks of defaults under loan agreements. If your business is still experiencing the effect of COVID-19, you might consider seeking certain accommodations or waivers from your lenders under your existing loan agreements. Similar to being proactive in approaching your landlord before you can't make a rent payment, borrowers should anticipate and proactively address liquidity needs and actual or potential defaults under their loan agreements. We've seen borrowers ask for and lenders grant amendments to loan agreements to allow borrowers greater flexibility while the effects of the pandemic continue. Borrowers will want to review their loan agreements and consider the financial and other covenants that are impacted by COVID-19. Like rent deferral, many borrowers have received payment deferrals on their loans. So requesting a payment deferral is a possibility, and I cannot tell you how many amendments I've drafted over the course of the past 6 to 8 weeks that involved 90-day payment deferrals or 120-day payment deferrals on loans. In addition, borrowers are seeking relief from their financial covenant compliance under their loan agreements. Seeking this kind of relief makes sense because the calculation of most financial covenants is directly affected by COVID-19 related losses, and violating a financial covenant under a loan agreement results in an event of default. You might consider requesting your lender waive financial covenant compliance for all of 2020. It's not ridiculous. Some lenders have, mostly because the COVID-19 issues surfaced in the first quarter and are ongoing. In some cases, in lieu of granting a complete financial covenant waivers, some lenders have agreed to reset financial covenants by increasing the financial covenant levels to account for the likely decreases in EBITDA due to the COVID-affected quarters. Also, borrowers should focus on the calculation of EBITDA under their loan documents, not only for the fiscal quarters that are affected by COVID, but also for post-COVID fiscal quarters. EBITDA is a major component of financial covenant compliance, and borrowers should consider how best to ensure that the calculation of EBITDA under their loan agreements is reflective of their business, notwithstanding the disruption by COVID. Many borrowers are requesting lenders to modify the calculation of EBITDA under their loan agreements to exclude the effect of COVID-19 impacted quarters. One example of this may be to use 2019 EBITDA in lieu of 2020 EBITDA for purposes of calculating EBITDA in a 4-quarter period. Borrowers might also consider modifying the calculation of EBITDA by adding back certain COVID-19 related items. Many EBITDA calculations and loan agreements contain adjustments which allow certain charges to be added back. So in the context of COVID-19, adjustments to consider might be extraordinary, unusual, non-recurring one-time items, goodwill impairment, lost revenue add-backs related to COVID-19 discontinued business operations, and possibly business interruption insurance proceeds. Borrowers may also need more time to deliver financial statements required under their loan documents. We've seen lenders approve 90 to 120-day extensions with respect to the delivery of financial statements. With regard to liquidity, there's all kinds of theories on how to secure liquidity. Many suggest that if you have a revolving credit facility, make draws on that facility now. Obviously, enact cash conservation measures, but also consider entering into interim term loan facilities or government-backed financing programs under the CARES Act, for example, PPP loans or Main Street loans. Just a word of caution, though, with regard to lenders permitting additional indebtedness, especially in the context of government loan programs, we have seen lenders require as a condition of their consent that a portion of those loan proceeds be applied to repay the lender's debt. Borrowers should also consider modification to material adverse effect clauses in their loan agreements to include a carve-out for the impact of COVID-19 on the borrower's business. Borrowers might also consider modifying negative covenants in their documents by a temporary lifting of restrictions on additional indebtedness so that interim term loans, PPP loans, and Main Street loans may be obtained to secure liquidity. Finally, in exchange for financial covenant waivers, borrowers should expect lenders to require new covenants whereby the borrowers need to maintain certain minimum levels of liquidity during a financial covenant waiver period. Some lenders have also tightened covenants related to restrictive payments and distributions, as well as permitted investments allowed to be made by the borrower in exchange for these financial covenant waivers. Finally, many lenders are requiring stepped-up financial reporting, in some cases weekly or even monthly cash flow reporting in exchange for these waivers. And don't be surprised by increased pricing or amendment fees as a condition to loan agreement amendments related to COVID. I know my time is almost up, but I just briefly want to touch on the Main Street Lending Program, which is also authorized under the CARES Act. Many of you have received PPP loans, and certainly these payroll protection plan loans have been in the news for the past several weeks. The PPP program is sunsetting on June 30th. What I mean by sunsetting is that after June 30th, you will no longer be permitted to apply for these loans. That's the expiration date. Just last week, the Main Street Lending Program kicked off. And what I mean by kicked off is a portal was opened by the Federal Reserve so that lenders interested in participating in the program can now register to participate in the program. The Main Street Lending Program loans are intended to provide financial assistance to small and medium-sized businesses. The loans are not forgivable, although they are at low interest rates. The programs offered by the Federal Reserve, minimum loan size is $250,000, and the loans may be secured or unsecured. To obtain a Main Street, within the slides, there are several slides about what constitutes an eligible lender or eligible borrowers. There's lots of ineligible borrowers that you can review at your leisure. I want to hit on something that was a big issue for the PPP loans. That is the idea of having to certify that you couldn't find credit elsewhere or you didn't have another source of liquidity. To obtain a Main Street program loan, a borrower must certify that it is unable to secure adequate credit accommodations from other banking institutions. However, the Federal Reserve has clarified that this doesn't mean that a borrower must certify that it has no other credit available. Loan terms for the PPP or the Main Street loans are 5-year maturity, interest is deferred for 1 year, the unpaid interest is capitalized, principal payments are deferred for 2 years, followed by principal payments of 15%, 15%, and 70% at the end of years 3, 4, and 5, respectively. There are no prepayment penalties. The interest rate is LIBOR plus 3%, and there are fees. There's a 1% origination fee, and a lender is expected to pay a 1% or 0.75% transaction fee to the Federal Reserve. And lenders are also able to pass that fee on to borrowers. So the Main Street lending program is not necessarily as attractive as the PPP loan program for several reasons, including the fees, the interest rate, and of course the loan is not forgivable. But again, it's an additional source of liquidity for borrowers who may be in need of that at this point. With that, I will finish up. Thanks, everyone. And there are 12 slides on the Main Street lending program, so please take a look after we finish up today. Thanks so much.
Thank you so much, Toni. And before turning the floor over to Tom and Peter to address bankruptcy, I did want to mention that the 12 slides that we didn't have time for about the Main Street lending program, as well as all of the slides, will be available to the audience afterwards. So with that, Tom, if you could address some of the bankruptcy issues that are front and center after the pandemic, we'd all appreciate that.
I'd be happy to. Thank you, Michael. This is Tom Scannell, the Senior Counsel in Foley's Dallas office, and my primary practice is bankruptcy and restructuring. I am joined by my partner, Peter Lowe, also in Dallas here.
Hi, everybody. Hi, Tom. This last section of the webinar will be a little bit different. It'll be a Q&A between Tom and myself. And Tom is going to address, as Mike alluded to, how bankruptcy impacts or can impact franchise, dealer, and distributorship relationships. In the first part of Tom's talk, I'll ask him to talk about how executory contracts that govern these relationships are impacted, or some aspects that you should think about when your counterparty is in bankruptcy.
Thank you, Peter. So many of the agreements that are involved in and oftentimes critical to the distribution or franchising relationships are going to be deemed as executory contracts in a bankruptcy case. These agreements often include dealer or distributor agreements, straight up franchise agreements, trademark licenses, equipment leases, and even more critical than anything else, a real property lease. We'll get into non-residential real property leases in just a few moments, but those are some examples of agreements that are often involved in the distribution or franchising relationships that are triggered by and often deemed to be meeting the definition of executory contract under the bankruptcy code. And it's important to note that executory contracts don't exist outside of bankruptcy. It's a defined term of art created by the bankruptcy code, and its definition is relatively straightforward. It's any contract or agreement that, as of the day the debtor files bankruptcy, there are material terms that remain unperformed on both sides of the contract. So that's all you have to do to meet that definition, and you will be involved or find yourself involved as a counterparty to an executory contract, and we'll find out here today what that means for you. And what that does mean is that, like it or not, you are bound to continue performing under that contract, regardless of whether you want to operate with and continue dealing with a debtor in possession or a bankruptcy debtor. The good news is that the debtor must also continue performing. The case law discussing this issue has, the bankruptcy courts around the country have said that it would be inequitable for a non-debtor to be bound to continue performing under the terms of the contract, but excuse the debtor from performing. So if you find yourself involved in an executory contract and your counterparty files bankruptcy, don't just take action. Continue performing. We'll talk about some things that you can do, but like it or not, just because they file bankruptcy doesn't mean that you're out. And quite the opposite, it means you are still in.
I'm sure that most of us or many of us on the call are familiar with the concept of the automatic stay in bankruptcy. Why don't you talk next, Tom, if you can, about how that fits into what we're talking about here with regard to these types of contractual relationships.
I'd be happy to. So, broadly speaking, the bankruptcy stay prevents any action to enforce pre-bankruptcy contractual rights without seeking relief from the bankruptcy court before you take that action. It's important to note that the bankruptcy stay is construed very broadly. So this is without a doubt an ask for permission, not forgiveness kind of thing. If you take action even unwittingly, you thought, oh, I didn't know. Ignorance is not an excuse here, and the punishment for violating the automatic stay can oftentimes be steep, and you don't want to run afoul of the teeth of this provision. So what this means, unfortunately, is even if your agreement or lease has a provision in it that says, in the event of a bankruptcy, the agreement can be terminated, and both parties are excused from further performance, that's called an ipso facto clause, and the bankruptcy courts have held that those kinds of clauses are not enforceable. So you can't contract around the bankruptcy code's provisions and the rights afforded to a debtor. The automatic stay prevents you from enforcing those contractual remedies that would otherwise exist outside of bankruptcy. Again, the emphasis here being that executory contracts are a special creature of the bankruptcy code. So if you find yourself in that situation, you are now bound by a separate set of rules that would not otherwise apply to your contract. So again, like it or not, the stay and the bankruptcy cases interpreting the stay and interpreting the enforcement of ipso facto clauses have said that you are bound and without absent or without seeking relief from the court and absent a court order authorizing you to enforce those rights and remedies, you are bound to continue performing, and you are stuck with your debtor.
Okay, so let's talk next about specifically what rights or what can a franchisor or a distributor or a dealer do when their counterparty is in bankruptcy?
Well, that's a good question, because we just got through talking about all the bad things and what you can't do, but there are some very quick and specific remedies that a non-debtor counterparty can take to get the relief they need. There's really three principal or main sources of relief, and one would be proactive. It would be a very proactive way to be aware of what's coming down the pike. And if for whatever reason your counterparty under the agreement or lease is showing signs of distress, and for whatever reason the nature of your relationship with that party, it would be very detrimental to continue doing business with that party in bankruptcy, then look very closely for an ability to terminate that lease or agreement prior to your counterparty filing bankruptcy. So terminations of executory contracts are just prior to bankruptcy. They're governed by state law and the terms of the agreement. So as long as you follow the letter of the terms of your agreement, dot all your I's and cross all your T's before they file bankruptcy, and I mean it can happen the minute before they file bankruptcy. The automatic stay and all those things that we talked about are not going to apply to you. So if you don't want you do not want to be doing business with a Chapter 11 debtor, be proactive and take action quickly so long as grounds to terminate the contract exist absent a bankruptcy filing. The second form of relief would be to seek relief from the automatic stay. So that bad thing we just got through discussing, it's not the end-all be-all. There are very specific grounds for relief so that you can terminate your contract even if the debtor's in bankruptcy, and retake your premises, retake your equipment, find a new counterparty as a substitute for that agreement. The general relief that's going to be applicable to the audience today is the general cause requirement under 362D1 of the Bankruptcy Code. And the most common ground for cause to exist is if the debtor is not performing under the terms of your agreement or lease. Again, cause being a very broad and intentionally flexible concept. Remember, the debtor has to continue performing, so you can't be held at bay performing and holding up your end of the bargain if the debtor is not holding up its end of the bargain. So let's say they've missed 3 or 4 months worth of payments, or they're not delivering goods, or the facility is left unclean or not in a commercially reasonable manner under the terms of the agreement. You can go into the bankruptcy court by motion and ask the court to let you terminate that lease or agreement due to the debtor's non-performance. The third principal option would be to file a motion to compel the debtor to make a decision about your franchise agreement or lease, because we'll talk about in a minute is the time frame for the options by which a debtor can choose to dispose of your franchise agreement or lease. Oftentimes, there may be a situation where the nature of your operations could present a scenario where waiting beyond a certain period of time just to have the debtor later decide to reject your contract or lease, it could cause irreparable damage to your business. Under those circumstances, that would be an example of when you could go to court and ask the court to force the debtor to make a decision and expedite the debtor's assumption or rejection of your business relationship. It can often be a very critical tool to practically save yourself a lot of money.
Okay, well, we just have a few more minutes here. Let's kind of combine these two concepts about assumption and rejection and talk about them together.
You got it. So briefly, the time frame, it's important to note, in a Chapter 11 case, other than a lease of non-residential real property, the debtor has until it confirms a Chapter 11 plan to decide whether to assume or reject the contract. However, if you are a non-debtor counterparty to a non-residential real property lease, the debtor has to make a decision within the first 120 days, which is subject to a one-time 90-day extension. So be careful of the time frame there. The debtor generally has 3 options. There's assumption and assignment, and rejection. Assumption is when the debtor, under its business judgment, which just simply means that looking out for the best interest of creditors, the debtor has run a cost-benefit analysis and determined that your contract is valuable to its going concern. The debtor can choose to select your contract as one of its material contracts going forward. If it does that, it is deemed to have assumed you, and like it or not, you're dealing with your debtor even post-bankruptcy. All it has to do is provide 2 things. It has to cure any defaults that might exist under that contract, both pre-bankruptcy and post-bankruptcy. And it can't modify, it can't force a contract modification on you. The debtor can't cherry pick the provisions it wants to keep and those that you really negotiated hard pre-bankruptcy for your benefit. The debtor has to keep all of it or none of it unless you consent otherwise. And then the debtor has to provide adequate assurance of future performance. All that really means is that they promise that they're going to continue performing and they're not going to have any future defaults. Assumption and assignment is the same thing, except the debtor first assumes the contract and then assigns it to an asset purchaser. So this is where the debtor files bankruptcy and is going to sell all of its assets. The party that is making the decision on your contract this time is the asset purchaser. The debtor first assumes your contract by curing it and providing adequate assurance of future performance, and then it assigns that contract over your objection now. So you're not only forced to continue doing business with a debtor, but you're forced to continue doing business with a new assignee that you did not select. Anti-assignment provisions are generally not enforceable. So if you negotiate hard pre-bankruptcy for an anti-assignment clause, you get into bankruptcy that's not going to be enforceable unless you're dealing with an intellectual property license or a personal service contract. And that's important in this context because many dealer, distributor, franchise agreements have one or both of those elements, so keep that in mind. And lastly, we've got rejection as an option. That all that means is that the debtor has decided that your contract is not valuable to its going concern value, and it wants to be excused from future performance under that contract. Again, also judged under the debtor's business judgment, a cost-benefit analysis that in the best interest of the creditors, your contract is more burdensome than beneficial, and the debtor is now excused from future performance, which also means that you now have cause for relief from the automatic stay. You can ask the court very quickly to provide you relief to terminate the contract, be excused from future performance, and take possession of the premises in efforts to mitigate any damages. You're really often your only source of relief when the debtor rejects your contract is a general unsecured claim for rejection damages, and those are damages that would be due in a lawsuit for breach of contract outside the bankruptcy context. It's the lowest class of creditors in terms of priority, so just be aware that you shouldn't be relying on any monetary recovery for your rejection damages claim. Oftentimes, they're paid pennies on the dollar or not at all, so beware of that. Lastly, covenants not to compete, oftentimes a very critical component to a franchise agreement. Most bankruptcy courts have held that covenants not to compete survive rejection. However, there are outliers that have held that rejection of the contract makes the covenant not to compete unenforceable. So oftentimes the suppliers or the counterparty's sole remedy is filing that general unsecured claim. Please beware of that and look at that closely in your particular jurisdiction. It looks like we are out of time. We'll open it up for any questions generally, not only on this topic, but the rest of the topics covered today. And please feel free to reach out to us for any questions or concerns. There's a lot of material in the slides that we didn't have time to cover today that we'd love to discuss further.
Thank you, Tom and Peter. We are past our official end time, but we had at least one unanswered question that for those who can stay on the line, Leslie Smith is prepared to address. The question had to do with force majeure clauses, and if there are others, if we can't address them during the seminar, we can follow up afterwards. So, Leslie, if you want to take that question, and then we'll close.
Sure, I'd be happy to briefly. So the question had to do with whether a business, this was a supplier in this case, who was selling its products to a particular purchaser. The purchaser was reselling the product on its location. The location is closed. The supplier had an obligation to make a monthly minimum payment to the university, or quarterly a payment, and the question was, is there still an obligation in light of the pandemic and the fact that the location is not currently open? So I would say that's something like a minimum royalty payment in a franchisor agreement. First, I would turn to the force majeure clause and see if the event is covered specifically by the clause. That may give you an avenue to excuse your minimum payment obligation. But alternatively, if that isn't covering you in this particular circumstance, you might be able to argue that it's a failure of a condition precedent, which is that the purchaser has an obligation to purchase your product from you, and that's the condition precedent to you actually making the quarterly or minimum payment. So if there's a failure there, you might be able to turn to that as another contractual defense, or alternatively, looking to common law and statutory defenses, particularly those that might arise under commercial impracticability, under the UCC for the sale of goods, or frustration of purpose with regards to the contract. So that's my response. Hopefully that is helpful to you.
Wonderful. Leslie, thank you very much. And in closing, I want to thank you all again, and also mention that in our coronavirus webinar series, we will be having at least one more, although the Paycheck Protection Program, loan program, as Toni mentioned, is about to end at the end of the month. The next wave of activity will come as companies apply for forgiveness, and also as the SBA does what it has announced it's going to do, which is audit many loans and in some cases try to claw them back. And last but not least, we will be sending out announcements in the near future about our next annual Law of Product Distribution and Franchise, and hope that everybody will be able to join us. Thank you.